I turn to the creation and evolution of the international tribunals. It started, it seems, in the late 15th century with a case from 1474. Peter von Hagenbach was a knight, a military commander, and land guardian of a town on the Rhine called Breisach. He was tried before a tribunal of the Holy Roman Empire of committing atrocities during the occupation of that town. His defense was that he was just doing what he was told to do by the Duke of Burgundy, who was the controller of Breisach by decree of the Holy Roman Emperor. That defense of von Hagenbach was rejected. It was held it's not good enough that somebody tells you to do things that are criminal, and if you do them, you are personally responsible. And he was convicted and he was beheaded. And this is seen as the first case of superior responsibility being no defense, which was the predecessor of the modern war crime trials, which began with Nuremberg. Now, in 1648, the Peace of Westphalia brought to an end the 30 Years' War involving the Holy Roman Empire, of which I've just spoken, and at the same time the 80 Years' War between Spain and the Dutch Republic, in which I'm sitting. From 1648 until 1945, states claimed a monopoly of authority over international crimes. There was nobody else to enforce any form of international criminal law. Only domestic law applied, and as a result, those who controlled the domestic law took care to make sure it didn't fall on their necks. Military leaders and high-ranking politicians therefore escaped liability for their crimes. Nuremberg was a watershed. It resolved the acute tension between sovereign independence of what nowadays are 193 states. It's still an important principle, but in addition, there is recognition that there is something even more important than that, and that is international criminal law to be obeyed by everybody, whoever they are. The creation of international criminal tribunals started at the end of the Second World War with the Nuremberg and Tokyo tribunals, was frozen during the Cold War until the early 90s. But after the war in the Balkans and the massacres in Rwanda, two new ad hoc tribunals were created by the Security Council. The International Criminal Tribunal for the former Yugoslavia, ICTY, and you can ask Olga Kavran about that, because that was her, I think, introduction to this topic in which she is now a master. The other one, the International Criminal Tribunal for Rwanda. Their aim was to prosecute and convict the perpetrators of war crimes in both international and non-international armed conflicts, as well as crimes against humanity and genocide. There followed in 2002 the creation of the Special Court for Sierra Leone, which has been sitting on the floor above us in The Hague and has just finished its work. And importantly, of great importance, the International Criminal Court, which is the first permanent international court dealing with crime, established by the Statute of Rome. It continues. 2 years later came the extraordinary chambers and the courts of Cambodia, the Cambodian Tribunal, and we followed in 2007. All tribunals I've mentioned except ours are mandated to try perpetrators of international crimes. And I mentioned war crimes, crimes against humanity, genocide and aggression. Our mandate, by contrast, applies, as I've said already, to the domestic criminal law of Lebanon. Specific provisions, those relating to terrorism and certain other crimes, such as homicide, including murder and conspiracy. So our purpose is to deal essentially with allegations of terrorism.